All right, everybody, thank you so much for coming. I know this is a busy day at the law school. There's apparently 5 events upstairs going on all simultaneously. My name is Lucy Rica. I'm the executive director of the Center on the Legal Profession here at Stanford. And I am pleased to bring together this panel. We have a couple of UK visitors with Karl Chapman and Andy Daws from Riverview Law. And we have Ralph Baxter, former chair of Orrick. And we've got Stephanie Kimbro and Ron Dolin. Ron is a fellow with the Center on the Legal Profession. Stephanie will be starting as a fellow in June. And we want to put together this panel to talk about some of the changes that are happening in the UK legal market, some regulatory, some just kind of market-based, and what those changes could mean for the US market. So I'm going to turn it over to them. We see this as a real conversation, so jump in as soon as you've got questions or thoughts or comments. I just ask that you come to the mics so that we can pick it up on the audio because we are recording for the web audience. All right, thanks.
Let me just start by re-emphasizing that this is discussion-based. So this, originally this was either a lunch talk from Riverview, then we included other people. And this is not supposed to be a formal, like we're interviewing them, we're really wanting to just get into a conversation around what's going on in England with alternate business structure. We want to start asking questions around how innovation occurs and the degree to which the business model matters or doesn't matter, what kind of ethics changes need to happen, and kind of a comparison to see what's going on in England and what that implies for, whether the ABA, I don't know if anybody here was at the Future Law Conference, but people kept nailing the ABA for holding up changes. And I think part of the issue here we want to look at is what changes really have to happen in order to facilitate, changing the way that we do things, or is that inevitable or not? I'd kind of like to open it up if anybody wants to just kick in topics of interest.
It just occurs to me it might be worthwhile for this audience, for our friends from the United Kingdom, to tell them a little
Explain
bit.
What's happening. Yes, that would be great.
Who they are, because they may not be known by everybody in the audience. Would that be okay? Would you like to?
Yeah, that'd be wonderful. Yeah. Okay. Go on, Andy. After you.
Please. So actually, what would be interesting then is just a raise of hands as to how many of you are familiar with Riverview law at this point.
Oh, that's good.
Okay, yeah, there you go. Maybe about half or thereabouts. Okay, so Riverview was really catalysed and born out of a lot of the changes that are taking place in the UK right now with the Legal Services Act. Are you familiar with the Legal Services Act and some of the changes going on over there right now? So fundamentally, the government undertook a major review in the UK of the regulatory framework for legal services. That culminated in the Legal Services Act 2007, which made a number of very sweeping changes. Is perhaps best known for the change that permitted non-lawyer ownership in part or in full of law firms, legal service providers, which by US standards obviously is a real hot potato and very much an increasing topic of conversation over here. In the UK it's happened, and Riverview, as I say, was born into that environment really. So that the changes fully took effect at the beginning of, or end of 2011, beginning of 2012. Leading up to that period, Karl, myself, and a whole host of others working at a business called Advisor Plus, which is an HR advisory outsourcing business, whose clients were coming to us and saying, actually, would you guys be interested in providing legal services? You take our advisory in this HR and employment space up to a certain point, but then you hand off to the in-house counsel or you hand off to our third-party lawyers. At that point, we lose an awful lot of the benefits that you bring in this space, the management information, the driving the right behaviours, the culture, a lot of the things that you understand that typically are unheard of at this point in the legal space. So there was a kind of pull from clients at the same time as we were being approached by law firms over there who were looking to either A, partner, B, license, C, be purchased. And the Legal Services Act was the umbrella that oversaw all of that. So there was clearly a big opportunity for us within Advisor Plus to move into that market, either A, to bolt something onto the existing business as a legal division, as it were, or actually did this merit an entirely new business in its own right. Maybe a good point to hand over to you on that one.
Do you want to just quickly give your background in terms of your career and actually your role in Riverview Law?
Sure, yeah, okay. So my background, primarily legal and publishing industry for many, many years. Headed up a department in Thomson Reuters in London, in the UK. a department that at the time was getting into the kind of electronic space and transactional, easy for me to say, transactional government and their e-agenda in the UK. At that point in time, Advisor Plus had some particularly niche content and tools that we wanted for a framework contract with the UK government. So I got to know Karl and his colleagues at that point in time. And after somewhat of working together, moved across to work in Advisor Plus, and then during our time there was obviously involved in those conversations regarding how we actually then enter the legal market and take advantage of that opportunity. I'm over here, so the decision was taken very early on. Actually, this merits somebody in the US. So this is a global opportunity. Not only is it a big opportunity, it's a global opportunity. New York seems a good place to start. We had a number of our lawyers, as we put together Riverview, who had clients already over here, typically many of them on the East Coast, clustered around New York and DC at the time. So the decision was taken, actually, let's invest in that global footprint from the very, very outset and put somebody over there to initially to look after those clients, to grow the business, to talk a little bit about what Riverview is and what Riverview is doing and prepare the way for actually a global expansion.
I'm Karl Chapman. I'm Chief Executive of Riverview Law, and I think probably the first two things I should say is we made a massive mistake in getting Andy out here 2 years ago. We put him in the wrong part of the US.
Yeah.
Should have been over here. Just from this morning, I realised that we actually relocated it to the wrong place. One of the reasons why we're fascinated and spending our time out here is because of the way in which you're advanced in tech. I think we're advanced in other things in terms of structures and business models. And I think the combination of the two are going to be very interesting. But we did take a decision from day one to have Andy based out in the US because we thought it was important to understand what was happening. In terms of Riverview Law, just give you a context in terms of our business. We had the luxury of starting with a blank piece of paper. And of course, if you start with a blank piece of paper, you can start building a business model from the customer up, not the law firm partner down. So our entire business model has been built on what is it that customers want, how do we satisfy that, and all the way through to the way do we organise ourselves and the type of people we recruit. So in terms of the business that we're focused on, we're focused overwhelmingly on corporations, typically mid and large caps. We thought, shows you how interesting business model changes, we thought in the early stages that small businesses would be the early adopters of our model. It's been large corporations, global businesses. And I think that shows you the size of the opportunity that's happening. So what do we do? Effectively, if you take large corporations as the proxy, we are focused on the 60 to 70% of work that large organisations do every day of the week, every week of the month, every month of the year, that can be packaged into long-term outsourced contracts. So we have a business model which is predicated on long-term contracts with blue-chip customers with high renewal rates. And that's very important if you think about it, because what that gives us is visibility of earnings. In terms of a business model, it's very much built on long-term visibility of earnings so that we can out-invest. We don't pay dividends. We're a corporation. We're not a partnership. We have no partners. We don't pay dividends. We invest in the business. We've got a capital-driven model, not an income-driven model. Key thing to say about our business is that I think last time I looked, 96% of our revenues are fixed price. So we do a little bit of hourly billing where the customer wants it. We prefer not to because we think the fixed price model drives the right behaviours in terms of the way we interact with our businesses and also in terms of the type of people we recruit and the way in which we manage our business. Probably the other thing I should say before we go into a more general conversation is what a fantastic opportunity this is. I have to tell you, this is the third business that we've set up. We still own Advisor Plus, the HR outsourcing business. Our previous business in the 90s was a recruitment outsourcing business. This is the biggest single business opportunity I've ever seen. A multi-billion-pound global market, which is now subject to the normal disciplines and business pressures that come from proper competition. And I think that a lot of things people very flatteringly say about Riverview Law in the UK, I don't know what they say over here, that apparently our model is innovative and disruptive, and our response is very straightforward. It's only innovative and disruptive if you look at it from the perspective of the legal market, because everything we're doing is the application of common sense business principles which have been used in every other sector for the last 30 years, and the same principles we've used in our other businesses.
Do you want to say anything?
Well, I think we are going to see an experiment play out in the UK that will be very, very valuable to us in the United States. The UK, as all of us know, changed the rules not in order to make partners in Slaughter and May wealthy, by floating the shares of Slaughter and May, but in order to address the challenge that the ordinary citizen faces in accessing legal service. And the idea was that the model of traditional law firm ownership just will not lend itself to creating businesses that deliver quality and knowable legal service to normal people in the society. I'm right about that, am I not? Absolutely. We face in the United States, I think, two really big challenges in law that can, in today's world, given all the changes in technology and social orientation and so on, two challenges that can be solved. One is access to justice and otherwise access to legal service by the citizens of our country. And the other is delivery of legal service to the business community at fees, at prices that make sense in light of the value of the services being delivered. And that second problem is created by the manifest inefficiency of the traditional law firm model. And the access to outside investment and the discipline that comes with outside investment could accelerate the address of those inefficiencies in the legal marketplace. And we're going to find out, watching what happens in England, whether that happens. Because in England, what is already playing out, and here's an example of it, entirely new businesses are entering the market to compete head-to-head with traditional law firms. In the United States, that is not possible, because that would be the unauthorized practice of law. And so, and especially with the investors. So you're going to see that head-to-head competition, but you also will see more new companies that are in the world of doing parts of what is the practice of law. I think in England, even with a more conservative base and even without the drive of Silicon Valley. And so we'll see how does that play out in terms of advancing the efficiency of corporate law practice, as well as delivering quality legal services to the average citizen. So I think this is going to be very, very interesting.
I have a question about the culture and some of these changes that we'd like to see here happen in the States for the reason that you said. I'm wondering if in the UK, the culture around professionalism, lawyer professionalism, is a little bit different than it is here in the States. Because here, when we talk about changes to our model rule 5.4, which is the one that doesn't allow us to share with non-lawyer investors, it's that it wouldn't be professional to partner with or to take funding from someone who's not a lawyer. And I've even noticed the differences between the law firm websites on the UK, like and in Australia. Slater and Gordon, for example, has a client portal, and they market themselves. The big law firms market themselves differently than we do here in the States. And I think a lot of it goes back to our advertising rules being very conservative, and it's this concept of professionalism. And I wonder, in the UK, when you all were looking at ABS and researching it, probably looking at Australia as an example, were there those same cultural arguments that we're seeing here in the States that maybe had an impact or made it a little easier? Or?
It's a really good question. I'm not sure I know the answer to it completely. I think it's fair to say that there is a large proportion of the UK legal profession that was not happy with the changes that were made. And it's important to say that the changes were driven not by the legal community. The changes were driven by politicians for the reasons you described. So I think there's clearly a large proportion of the legal profession who are uncomfortable with the changes. I think the basis on which they're uncomfortable is flawed, because a lot of the debates come up about ethics and professionalism, et cetera, which quite frankly is nonsense, utter nonsense. And it's interesting, when we have the debate, one of the cultural debates we have is about professionals. Okay, so lawyers are professionals. Well, so are IT people, so are finance people, so are HR people. Professions, in terms of the way in which you want to define it, in terms of people in the business, they're all doing a professional role, and actually it's just the way in which we approach the definitions of it. So I think there is a big community in the UK, in the legal community, who are uncomfortable with what's happening. I think that they will naturally respond. I think one of the interesting things, Ralph, from your comments, which you're right, as to why it started, is the law of unforeseen consequences. They called this Tesco law to start with in the UK. Tesco is a big retailer in the UK. I think they were in the US for a while. But if you look at what happened, it actually is the customer, it's on the corporate side where you're seeing the massive changes. You're seeing huge changes happening in the corporate market as well. So all this will feed through into other sectors, and that will force change in the law firms. And, you know, the nice thing about this market opportunity is that there's not one business model that will succeed. There are many different business models that are going to succeed in this market, right through from tech models through to law firms getting it right. There are some fantastic law firms out there doing some very interesting things who will get it right and will grapple with the changes and those issues that come from it. Culture is really key, though, because the culture underpins everything. Because unless you get the culture right, then it won't succeed.
Let me ask a follow-on culture question. We were talking this morning about self-selection of lawyers in terms of their attitude about commonly they're more risk-averse, maybe working more solo, whatever, versus people who are more working on innovation and or engineering. And I'm kind of curious as we see innovation moving into law, what the barriers are and how much of that is, let's say, business structure based versus cultural based.
Yeah, so I think that there are a number of barriers that are addressed by the change in the English model. But as Ron said, we had a discussion this morning about this. The psychology of lawyers and the self-selection is such that the average lawyer does not have an innovative bent. We tend to be risk averse. We like following precedent. We like the idea that we'll do tomorrow what we did yesterday, and that's part of the issue in the pace of innovation in law firms. But the model of law firms is as well. The idea that we're these general partnerships and everyone is an owner, and we don't have the discipline in that model that a for-profit business would have. One of the things people worry about when they face the concept of having outside investors in a law firm is that the profit motive will end up trumping issues that are so-called professionalism, the quality, the integrity, the confidentiality, all of that. And of course, there's some risk of that in any business. But actually, the drive within the current model of law firms to make enough money to be competitive is so intense. I'm thinking it can get a whole lot more intense with outside investors. But at any rate, the current model doesn't have outside investors. It has sort of a committee of the whole. Even in the best-run firms, all of the partners have a say, and they should have a say. And so that slows the pace of change as well. And then, of course, we have the problem that we are very successful. The great law firms in the United States make a lot of money, have great clients, do great work. I mean, one of the things I always feel it's important to say is that great law firms are doing great work for their clients. And they're doing honest work and observing the standards in a complete way that the public would expect of these great law firms. The problem is that we are not as economically efficient as we could be. We don't think about as adequately how we assemble and deploy resources and how we change the way we assemble and deploy resources as we go through time. And that's what needs to change. But I think the model, ownership by the partners, is another real impediment to change. And what makes actually the Bay Area so different is that the firms that originated here tend to be different on all of these fronts. Fenwick certainly being a leading example, but Fenwick and Wilson and Cooley have a different mindset here in the Silicon Valley than the average American law firm, as do the other California law firms, even the ones that come from LA and San Francisco.
Is that different mindset in just the culture and attitude, or is it business structure change?
Now, the business structure is we all are different. We're all different from each other in one way or another. But there's a more open-minded spirit in California than New York City.
I knew we put Andy in the wrong place.
So there are lawyers at Riverview.
Yes,
They are somehow employed as non-partners.
absolutely.
Maybe they get equity.
They participate, get salaries, and participate in equity.
So what's the difference? Because are there the same impediments among lawyers in the law firms? And somehow, because you switch to an equity system, they don't vote anymore, or they vote by shares, or what's the difference?
I think, as a reference to the front end, we had the advantage of starting with a blank piece of paper. So we were able to build our model from that base up. So The way we operate is that we have dedicated teams on accounts. So if you work for that bank, you don't work for that telecoms or that retail business. You can get promoted into different roles and into different accounts, obviously, but you start working from a particular point. And as a result, when we're assembling our teams, one of our key competencies is our ability to put the right team together to service that customer on whatever the service scope is. So when our lawyers are joining our teams, and they are one member of the team, because there are lots of other people in that team, they know what their role is, they know what they're participating in, and they know how to work. So they're very much focused. We aren't interested in lateral hires and people bringing a following. It's irrelevant to us. We're interested in their style, their culture, their fit, their attitude. And they've obviously got to have the appropriate quality. But we are sitting there with long-term contracts, fixed price. We're bringing people into the account, so they understand their roles from day one. So in terms of the culture is very different because we don't measure people and reward people on billable hours. So our whole reward mechanisms are different. Our measurement is different. If you think about our model, and the key for us is renewal of contracts, which goes to quality. You don't renew contracts unless you deliver a fantastic service to customers at a sensible price, delivering innovation and everything else that goes for it, MI and data. So as a result, when we're measuring our people, you're not getting a phone call on a Friday night saying, how many hours have you billed? It's irrelevant. They're working there within contracts, and we're measuring quality. We're measuring the service delivery. We're measuring we're measuring the way they communicate with clients.
So this is all doable in a law firm structure. And if you started a law firm under the old rules, you could start it in this way, couldn't you?
Oh yeah,
I guess I'm kind of focusing on
structure.
Does ABS really matter, other than that it's simply that you had existing business models from other sectors that you then brought into law, and that wouldn't happen if the law firm was only owned by lawyers. So it's more of a cultural issue than it is.
And I think also the structure of a corporate entity opposed to a partnership also has some other advantages. So for instance, so for a corporate structure, I mean, if tomorrow we decided, having had a fantastic morning, that we wanted to raise £100 million to turn our business on its head and become a technology-driven business rather than just a technology-enabled business, it's very hard to do that within a partnership model, because where are you going to fund it from? You're going to fund it from either the partners or a bank. In a corporate structure, we can do it by raising capital in an equity environment and a mix of debt if necessary. So I think the corporate environment gives you an ability to raise capital in a different way and then finance things in a different way and reward people in a different way over the longer term. I think in terms of the cultural point about a partnership could do some of the things we're doing, yeah, of course it could do. It comes down to the way you operate. I think the thing about ABS is, the key thing about ABS is, for people like us, I read law, never practiced. I would never, ever have thought we could enter the legal market, because I thought, having bought legal services for 20-odd years, that only law firms could do it. So what did ABS act as? A lightning rod to say, there's a global marketplace here worth multi-billion pounds, and by the way, non-lawyers can now invest in and own law firms. So where ABSs were very important in the UK, it was a lightning rod for change. Because the biggest change in the marketplace is the customer. It's not actually the structural bit. The structural bit gives us some advantages. We had a blank piece of paper, that's an advantage. We can raise capital, that's an advantage. We can reward people in a different way, clearly that's a slightly different advantage. We're not, at the end of each year, distributing profits to partners. We're not doing any of that. We're investing in the business. So if you think about it, there are some different structural things, but the key thing about ABS is it's a lightning rod, because it's allowed people to say, how do we get a part of this multi-billion pound marketplace? And that's why you're going to see some massive investment over the next 2, 3, 4 years in the UK in vehicles which actually attack the marketplace on a global basis.
And to the reward point as well, just important to make clear, maybe it's not only the lawyers in Riverview who are potential owners of options or shares within the business, as we'll call it. So it has a very different ethos, a very different atmosphere in which you're incentivizing potentially the most junior employees alongside the most senior lawyers with the same stuff.
And culturally, we don't have the language. We don't have lawyers and non-lawyers. We don't have fee earners and non-fee earners. What a load of nonsense that is. What an insult to the people who are not lawyers. I mean, the language is disgraceful. We have people in a team and they work for one business delivering a great service. It's as simple as that.
There's a question there.
Sorry?
Please. You might want to use the mic, I guess.
There's just one now.
There's just one.
I'm wondering if the reforms or the surviving professional rules specify a particular role that attorneys or lawyers must perform in these entities, or not.
Yes.
What are those?
Right. So as an ABS, there's a thing called, and I love the way in which the legal market comes up with loads of acronyms, but I guess every market's a bit like it. There's a thing called a COFA and a COLP. And a compliance officer for legal practice, That person has to be a very senior lawyer who's responsible for all the things you'd anticipate in terms of supervision, quality, and all the other regulatory requirements. So you have to have that role. You have to have that person sitting on the board, so they have to sit on the main board of the company. And after that, you can structure it as you see fit. There's a reality, of course. I mean, if I take our business, 43% of our entire team are qualified lawyers, ranging from newly qualified through to people who've been general counsel of businesses with 20 plus years experience. So, and it's interesting as an aside, the one thing I thought we'd have the biggest problem with in setting up our business would be sourcing the right people to deliver the service to our customers. That's not a problem, because in the UK we have a massive oversupply of lawyers. I don't know what it's like in the States, but it's our legal and education training system's got a lot to answer for. So there are roles which are specified, but clearly if you're delivering services to customers, and these are FTSE 100 and Fortune 500 businesses, you have to have the right people delivering the services. And that is a mix of qualified lawyers, yes, paralegals, yes, data analysts, yes, IT people, yes, climate. It's the mix that makes it work. And clearly one of the things we're looking at is how to actually keep on driving that forward in an effective way.
And actually that follows a similar pattern, although not identical, to what happened in Australia, where of course they had similar liberalisation even before the UK, and were given some direction around, okay, this is the way in which you need to bolster the compliance within your incorporated legal practice, as they call them over there. But actually we're going to give you somewhat of a free rein in terms of how you piece that together, as long as the outcomes are there and you can actually prove that you're monitoring that aspect and allaying any fears about the wrong influences.
Could you please just, sorry for the hassle, but just so we can get it recorded, if you wouldn't mind going to the mic.
Thanks very much. By way of introduction, I'm Paul Payton. I was a reporter to the ABA's Ethics 2020 Commission for Alternative Business Structures. And now that I've been freed from the constraints of 2 years of entire frustration, I'm able to speak my mind.
That's brilliant.
Very glad to be here, and thanks very much for organizing this. I'm also a former fellow of the Keck Center here, and so it's nice to be back. One of the things that I found quite astonishing when I was in the UK last November for meetings with the Law Society and also Legal Futures Conference was the distinct absence of large law firms from the dialogue or debate. Now, one of the features that I'm writing about in terms of the history, I call it my personal therapy, in terms of dealing with the Ethics 2020 Commission was the absolute absence of large law firms from any discussion or participation in the ABA's Ethics 2020 Commission dialogue at all. Where do you see from the Riverview law perspective, first question, the large law firms who are hovering around ABS, moving in the UK, quite interested in capital formation, but not necessarily the other market prerogatives that you're talking about? And then secondly, to Mr. Baxter, in terms of the future dialogue in the US, given the abject failure of any movement forward by Ethics 2020, if your firm or others are interested, how do you move it forward?
In terms of large law firms in the UK, and if you just take the top 100 law firms as an example, long may they continue not to participate in the discussion and the dialogue. And I think a lot of the reasons is because many of them don't see it as a threat. They've been highly successful. Partners are still paid ridiculous sums of money. I'm exaggerating to make the point in terms of generalising. But if you cut right down to it, it's actually quite difficult to get a consensus view within a law firm because of its nature of the partnership model, the structure of that model. And we know a number of senior partners and managing partners in law firms who know exactly what they need to do, but they can't do it. They can't do it for many reasons, ranging from they can't get it through the partnership, they don't have the capital for the transformation required, particularly the investment in technology, and by the way, and the change in people, because it's as much a cultural transformation as it is anything else. So I think, interestingly, the large law firms, many of them towards the top end of that top 100, won't see people like us as a threat. And again, long may that continue. Because what they fail to realise is, of course, what we'll do is what's happened in every other industry. You start off here and you go up the value curve. As customers become more and more confident and comfortable with the model, they start saying, thank you very much. So I think from our perspective, it has been a surprise, I have to say. I read law, never practiced, but I have been surprised by the lack of response from many of the large law firms. There are some exceptions to that. You take Irwin Mitchell, I think they've got 4 or 5 ABS licenses. They've certainly got at least one. So you are seeing some move and find ways to do things, but they are the exception rather than the rule. And I suspect that'll be the case for a while until there really is a burning platform.
So I want to hear from Ralph on this, but I don't know who here has read Innovator's Dilemma, but it does speak to the issue around going new players coming in bottom market and moving upscale while the top players keep going up market until there's no market to maintain it. And we do expect to see failure among many of the large firms because of some of this.
Well, the Innovator's Dilemma applies fully
Perfectly
to this situation. And again, the driving reason that you don't see the major law firms, and you didn't see it in England either, actively participating and considering this kind of reform is that things are working just fine. And from the standpoint of the businesses, and I'm always worried that I will sound, as I say these things, negative about big law. I'm not. I mean, they're great people working hard, doing great service and all of that, but they've got a business model that works just fine for them. It's challenged, it's harder and harder, but it's working fine. And remember, the energy behind this reform in the United Kingdom didn't come from making commercial law firms more profitable or run better. It was about, social policy issues. So in the United States, one observation I'll share with you. When this reform was being approved, I would talk to my friends who run large English firms about how they would then make benefit from the change. And they all said, oh, well, that's not for us. And I thought they were kidding. I thought they were just saying that because they were English and, understated.
We're like that.
Yeah, but they weren't. They weren't. So so far, they're not taking advantage of the opportunity to raise capital in a different way. I don't expect that large American law firms will be active on this subject unless they see it going in a way that they think is wrong. And I mean that wrong. I don't mean just selfish out of their interest, against their interest. There's often an idea that develops that the law firms are carefully protecting their own turf. They don't need to work to protect their own turf. It will happen by virtue of these ideas of professionalism, and we've got to protect the consumer against malpractice, and so the rules will stay nice and conservative. But I think if the law firms perceived that the ABA or the legislatures of the states were going to adopt principles that they thought were not sound for the profession and so on, then you might see a different outcome. But this is one of the reasons that I think the energy for change in the delivery of legal service in the United States is not going to come from big law. It's not going to come from the clients. It's going to come from entrepreneurs supported by investors in driving new ideas, many of which will fail, some of which will succeed, and will bring new ideas, new disciplines to the delivery of legal service. And it is why I think it's going to be very important that we reconsider our ethical rules as we go along so that we don't get in the way of progress that would be good for the public. We had a very good discussion in Future Law last Friday, I thought, here, about the issues that need to be reconciled in me seeing to it that we do protect the interests of the client, of the consumer of legal service, but at the same time permit innovation, because without innovation, we're really not protecting the interests of the public.
I think something else just to add on that. I think the other answer to your question is also, and you've touched on it there, Ralph, and I think spot on, is that many of the law firms are uninvestable. If you're a private equity organisation, it's very difficult for you to invest in a law firm given the current structure, because what are you investing in and what happens to the money? Because if the partners want to take it out, hold on a second, we want to grow the business going forward. So I think many of them are uninvestable. And I think that's why you will see what you've just hinted at, which is I think you'll see a lot of the investment bypass the traditional legal infrastructure, and it will go into tech. And that will end up as another catalyst for change, which will drive things back in terms of change in the legal profession. All to the benefit, by the way, the big winner in all this is the customer. Whether that's a consumer or a corporation, it's the customer. The customer will win hands down.
So you may have partly answered this, but I was in London a few weeks ago at a session on what was going on in the legal profession, and there was somebody there from the Solicitors Regulatory Authority, and she mentioned that there hasn't been as much, quote, take-up when in response to the ABS as had been expected. I frankly interpreted that as being there weren't as many Riverviews around as were expected. But from your discussion, a piece of this is that law firms have not responded. Like I think all of you have said, I wouldn't have expected to see the response coming from traditional, very successful magic circle firms. What is going on in terms of take-up? And then a second question, going back to the issue of the culture and politics of this. Ralph and Karl, I think you both mentioned that the decision in the UK was a social policy decision. It wasn't pushed by the big law firms. Who was that social policy decision supposed to serve? That is, were the politics of this truly a kind of access to justice Tesco law, or was it that big corporations that are asking for more cost-effective services wanted to see this happen?
You may want to pick up on this as well, Danny, but it wasn't big corporations. It certainly wasn't the latter. I mean, the thing that always surprises me is that General Counsel have always had it in their hands to change the legal market. They've just chosen not to. I think now you're seeing more pressure placed on them, and they will change it. So that's why I think the customer was a big change. So the drive was access to justice. And I think it's the same in the US. There are huge unmet legal demands, and the legal profession has created an infrastructure which cannot cost-effectively satisfy them, which is why you'll see the growth in tech and alternative delivery models to actually satisfy. So the drive was very much at that consumer access end, and also breaking up a monopoly. Because in a sense, you can trace some of this all the way back to Margaret Thatcher. And it shows you how successful the legal market has been, that they were able to delay it for so many years. But you can trace some of the seeds for it back to that. And I forgot the first part of your question. Yeah, the take-up rate. The take-up rate's interesting. I mean, I think if you look at most of the ABS applications that have been approved, they've mainly been focused on the consumer market. There's been very few focused on the corporate market. And they've been mainly focused on things like personal injury. So they've actually been focused in a particular area where you could drive in efficiency using technology and had high volumes. And it's where these things start. This is where they start. They can start seeing efficiency and the technology starts coming through. I think part of the issue is what they always anticipated is you'd see private equity firms taking stakes in law firms so they could get access to these phenomenal revenues. Then everyone realised that these phenomenal revenues disappeared every year because they got paid out to partners. So hold on, I didn't have the phenomenal revenues. So because law firms became uninvestable, you didn't see what they anticipated, that law firms would raise capital using that model. So that's why there's not been a take-up in the way they anticipated. I think the surprise for everyone will be, and you've seen it already, I don't know whether you've picked up, because this is a major movement, the UK accounting firms, the big four accounting firms globally, are getting ABS licenses. Now, once you start seeing big accounting firms getting ABS licenses, you know the world is changing. And the difference for them is they're going to hit it globally on a vertical basis. They won't be trying to create all-service law firms. They'll go globally by global mobility, which needs a combination of tax, relocation, employment law. They will actually go down a route like that. And of course, they won't stop there, will they? They'll expand beyond it. So I think you're starting to see now the big entrance. And how long are we in now? 2.5 years?
Yeah.
So we're not that long in, interestingly. So, and I think the take-up's going to accelerate. And it's the big ones that make the difference, and you're starting to see that now.
And that's coming on stream. So it starts to get more interesting. I mean, as Karl said, many of the early entrants were PI and less exciting and substantially changing, market-changing entrants, as it were. But there are now, latest statistics, I think there's over 300 ABS licenses now been approved, well over 500 applications, so 200 in the wings. That we qualify as one of those with a license that's just been granted from the 1st of June. So there are large numbers there. Some of it not terribly exciting, but the exciting stuff is starting to come out now. With Capita is another interesting one. So major global player, not so big in the US, interestingly, but certainly across Europe and other parts. 60,000 odd employees, major outsourcing organisation who are buying a law firm and moving wholesale into legal services. That's the kind of shifts that we're seeing that will be market changing. Incidentally, anyone interested in how this the change came about in London, there's a quite complete report that was produced, the Clementi report, is that what it's called, that deals with all these subjects. You can see what was driving it, and that it was not about the corporate interest.
Can I have a quick question about, so if the majority of these new structures are dealing with personal consumer legal services, personal injury, things like that, I know here in the States, a lot of those services are handled by solo practitioners, and that's actually the largest number of lawyers we have in our country, and will continue to be, don't work for big law firms, they're solos. So I wonder how this has impacted solo practitioners in your country, if they are going off and collaborating with these companies, or if they're struggling even more under this. I know a lot would be interesting.
It's a really good question, and I think we're starting to see a lot of law firms choose to voluntarily close, not to continue, because the competition on the high street is so intense. And I think that's happening anyway because of the nature of the way the market's going. So you're seeing a reduction and a fragmentation and a change in the marketplace occurring, which is only going to accelerate. Absolutely only going to accelerate.
See, the problem is running a sole practitioner law firm is a challenge. If you're the sole practitioner, you're the marketing department, you're the IT department, you're all those stuff. And that, in the end, makes the amount of money you need to charge for each engagement higher than it would be if you were part of an organization of 50 similarly situated people who had the economies of scale in the marketing and the this and the that. That's part of what this Clementi report and all this change was designed to permit, so that the person who wants to be that sole practitioner, who wants to have that kind of practice in that kind of community and so on, the attributes the person is looking for, can do that with a cost of doing business that's low enough that he or she can make a living amount of money without charging the client more than the client can afford to pay.
So this is interesting because our incoming president of the ABA, William Hubbard, one of his big issues that he wants to tackle in his presidency is that we have this huge number of underemployed and unemployed lawyers. It sounds like ABS may actually open up alternative ways for them to practice.
Absolutely.
Any shadow of doubt.
Right, there's no question.
Yes.
Right, but we don't have ABS in this country. The Bar Association of which he will be president doesn't happen to have this sort of thing, right. for reasons known quite well to some of us. But really, that's what Richard Susskind talks about in his writing. Where are the jobs of the future? And this is a really important idea for an institution like a law school. Where are the jobs of the future? They're not going to be the jobs that were out there when I graduated from law school. So there will be some of those, but not enough to employ all the people that are getting law degrees. They're going to be very different. But this is one way to use those resources for the benefit of our society.
Well, and so in the next, just picking up on that point, I'm conscious of the question, but in the next 5 to 7 years, I should be fired as chief executive of Riverview Law if we're still recruiting senior lawyers. Now, think about why I've said that. Because if we've recruited properly over the last couple of years, and if we recruit properly over the next couple of years, we should be growing our own. We can now take people out of school at the age of 16, and they can go through an apprenticeship program all the way through to become qualified lawyers in a similar time frame to going through a traditional legal route, i.e. going to university, getting a law degree, and then going through law school. So they'll have worked with us, they'll have been paid, they've got no debt, and they've got phenomenal commercial experience. We can take people out of college. We can take them out of university. We can take them from their first job. So what you'll see organisations like us deploying sensible business practice where we grow our own. And I think that's going to have a massive impact in terms of the legal, but you'll see in terms of access to the profession, it's going to widen it dramatically. The other thing I think is going to pick up in terms of sole practitioners is the squeezed middle that's going to get hit hardest. It's going to be absolutely, if you take those mid-tier law firms rather than sole practitioners, there's always going to be the role for the sole practitioner in a local economy because of their relationships. There's always going to be a role for the top firms, although a lot of them there'll be some boutiques splitting out of them. But it's the squeezed middle that's going to find it almost impossible to compete over the next 10 years.
So these discussions, both in person and on the web, always sort of, and in books like Suskind's book, always centers around the fact that traditional partnerships, the AmLaw 100, the AmLaw 250, the partners.
That's it. Pick it up.
Is this better?
Hey.
Works? Okay.
Yeah.
So. Okay. So all these discussions tend to center around this point that traditional partners and partnerships in the big law firms, there's simply not enough money. There's not money or capital for them to invest, and they need to go someplace else. It always strikes me as odd because partners at the large law firms have huge piles of cash, relatively speaking, right, to invest in what is their business, right? And they have the most to gain from doing this. If, in fact, the issue is simply making a more profitable firm, it seems to me an alternative reason for that is that they innovate themselves out of the particular position that they're in now. And it seems that they're never going to go for capital outside or inside if that, in fact, is the outcome. And just your thoughts on that.
Well, I think you're not right about the last part. And if you are, it's only because we aren't good enough business people to figure out how to use that capital. The problem with capital in law firms, and when you can't have outside capital, is the only capital you can raise is after-tax income, which is very inefficient, or debt. But that's how you access capital. And now in the UK, the law firms can, but they're not doing it yet, but they could access capital in a more efficient way, in the traditional way, from venture capital or other investors. That's the problem with it. We do raise capital. At Orrick, during my time at Orrick, we retained 5% of earnings every year. And we use that to build the firm. But that meant that every partner's got a very large capital account, and we're larger than one of the largest rates in the U.S., because that was our philosophy. But it was painful for the partners to do that, and it's a anyway. So there's that. The idea that law firms will not innovate because it will reduce their revenue. I mean, however you look at it, I don't think that's consciously so. I think that the law firms are wedded to the way they do things, and the market is not yet in the way that it will come to in time, responding negatively to the practices that produce these very high fees. As the market responds more, which it will do as we face more competition from third parties, then I think you'll see the law firms change more. But I don't think they're doing it in order to featherbed or something like that. I think they're doing it because they know that works. We know that if we do it the way we've been doing it, using mainly members of the Stanford Law Review and so on to staff up the cases and all the other things we do, then we produce very good outcomes. I think that's the main driver. And we don't seem as a group to have that business discipline to drive ourselves to do things differently. You know that at Orrick we moved 15% of our workforce to Wheeling, West Virginia. And that was just in order to do just what you are saying. And many firms have copied that, but most firms don't do things like that.
So how much money is needed for the investment? I mean, to do the ABS, right?
How much money is needed to do?
There's a discussion that there's not enough capital, or they have to go to capital. How much capital is actually required to pull off what you guys are doing?
Well, that's the irony, not very much. And I think it goes down then to culture, mindset, what business you're in, what you're trying to achieve. And I think fundamentally it goes down to we are capital driven, not income driven. And ironically, I would argue, by being capital driven, if you think about the consequence of that, that means we have to have long-term contracts with high renewal rates. Our focus on quality is mind-boggling because you don't get renewal rates otherwise. So I think there's a very fundamental structural change between capital and income-driven models.
Yeah, to me, the policy, if I might, just the policy issue on capital, the access to capital by private law firms in the United States is partly the efficiency of capital, so it would be less expensive. But it's also this idea. It would create an appreciating market value of the business. Law firms, American law firms, however great they are worth precisely zero. You can't sell a share in a law firm. That puts undue pressure on ordinary income for the partners. And if a law firm, and I'm one of the few people in the world that believes this, but I believe this, if a law firm had a value and it could appreciate over time, that would be an alternative way for the partners to be rewarded for what they are doing to build a business for the long term and to earn income, and that would have a benefit to everybody in the end, I think.
And the first law firm that breaks ranks and does that will have a major market opportunity.
Let me ask a question. Sorry, you raised the issue of needing to maintain quality. And I'm always very curious how quality is maintained or what the metrics are, and including in that quality of your lawyers, quality of the service. So, yeah, what are the metrics, or how does that work?
If you start from a premise which is we're not recruiting, we do have a running spare capacity, but we're not recruiting lawyers speculatively. We're not recruiting people to come in with a following and therefore generate revenues. We're recruiting people against contracts. So therefore, we've worked with the customer in terms of understanding what the service scope is and what skill sets are required on that role. So that would include all the way through from, yes, junior support people, all the way through to the most senior people that are required on it because of the nature of the work, whether that's somebody with 10 years experience, 15, it doesn't matter what it is, but they've got the right quality. So in terms of quality of the technical ability, that's very easy to satisfy and work. We're interested in making sure that technical ability is matched with cultural fit, and that's the biggest challenge, quite frankly, is getting the cultural fit. But that's how we start with that one. In terms of then how do you measure quality, there's a whole series of things. Because we're not measuring billable hours in terms of how many hours you build, everything is focused on. So to give you some simple examples, if you take part of the quality in our relationship being the power of the management information that we provide to our customers, which give them business insight and allow them to preempt future risk and future cost, that means that the people who are client managers and legal managers on our accounts have to be responsible for quality in the sense of not just the technical advice, is it accurate, does it fit the commercial risk appetite of the organisation, but also is the data input properly in the workflow processes so that we've got accurate data which allows us to provide appropriate information.
Are you allowing your clients to measure their ROI on their spend to you?
Effectively, at the front end of the, and on an ongoing basis, at the front end of the engagement, there's a very clear return on investment case because invariably the option is they either do it themselves or they use a third-party law firm, and then on an ongoing basis, all the metrics and the data, obviously we can all work out because we share it with them and we work through it in terms of the cost going forward and the return. So it's fully transparent from day one. Like it would be in any other business.
Does that map to American firms?
Which part?
The measurement of quality. ROI that the corporate client might want to be able. I mean, I've heard when I talked to General Counsel at Google, who I mentioned you earlier, said that they don't measure ROI on their legal spend because they can't measure quality of the service.
Right.
I'm just
they
wondering.
don't measure. The clients don't measure.
Right. So do the large firms measure?
I mean, no. Do we measure return on investment for our own investments?
For your clients, or measure the quality of the service delivered?
We measure, this is a really important issue, we do measure the quality of the service, but we measure it by our standards, and we measure it, and we measure that really fundamentally. Quality is measured by the results within a law firm. It's not a business question. It's in the way that you're thinking of it. It's a question of, did we do a great job at merging those companies, selling that company, winning that case? That's the measure, and that should always be a measure, but it shouldn't be the only measure. We should be more economic about what are we spending and what are we achieving for us and for the client.
In terms of quality, one of the things that, I don't have any of you read the book Moments of Truth by Jan Carlson? No reason why you should have done. Probably the best business book I've ever read. So Jan Carlson, Moments of Truth, our entire business is predicated on the basis of this. Moments of truth, all of our relationships with customers internally, we have these key moments of truth, which are the key moments when we know whether we've been successful or not, both internally with our own stakeholders, but also externally with customers. Some of the big moments of truth for us are, we've been engaged by a customer on a 3-year contract to do commercial contracts and obligation management. Key moment of truth is, when do they ask us to do something else? How quickly do they actually get the experience of what we've done? Because that starts feeding back into the quality. They don't do that unless we're delivering a phenomenally high quality service. We probably have the ultimate quality control mechanism. Do they renew the contract?
Yeah, thank you. First, a brief comment and then a question. I've held a number of senior roles in in-house legal departments in Silicon Valley, procuring the type of legal services that you're talking about, you're focusing on. And over time, I came to recognize that American lawyers, mostly other lawyers as well, we're not trained, we're not of the experience to think about legal issues other than transactional, anecdotal situations. And as I transitioned in-house and spent a long time in-house, I learned that what lawyers often are missing is the operational experience, familiarity with concepts like Six Sigma and Lean, and the ability to scale legal advice to a high-speed, high-volume business environment. And I think law firms aren't recognizing that, but in-house lawyers are recognizing that. And what you might be, the market you're capturing may actually be in-house legal departments outsourcing some of their operations to you. But that's, I think, the way what you've described is certainly why you're getting a lot of in-house legal traction in engaging. And I think it's why big law firms have a gap. My question, though, is you all are deployed to the U.S., maybe the wrong coast, but I'd like to hear more about...
Definitely the wrong coast.
Yeah. Where are you able to displace U.S. legal service providers? What has your experience been? What regulatory burdens or barriers do you have to doing that? And if you're right about the Big Four being able to move into this space, are they also going to be able to follow you in displacing in the U.S. market, if there aren't barriers to you doing so now?
Do you know, I'd love to think that the Big Four were following us. That would be absolutely fantastic. I think, just to quickly go back on your previous point, because I think it's relevant, the thing that effectively we're being engaged by large organisations in one of two scenarios. Number one, it hasn't worked with their law firm panel arrangements and they want to get rid of them, and we're an alternative to that. It's much more effective. Number two, they either have already or they're about to take it in-house, and we're an alternative to them. Why would they do that when they can do it through us? And I think the thing that surprises me, by the way, one of the reasons we get such traction is because when we speak to general counsel and we ask them why they're building the size of their in-house function, they say because it's cheaper for us to employ lawyers than to use law firms. What supply chain creates a situation where it's cheaper for the customer to do it itself? Tells you all you need to know about the infrastructure. Tells you everything you need to know. But what's interesting for GCs internally, if they're not careful, it's a short-term labour arbitrage, and that's all it is. Because they can't sustain it over time, because invariably, I don't know what your experience is, but whenever we speak to GCs, if I went in-house tomorrow and I asked the question, so what happens next? Well, I deal with legal matters. Okay, so where do they come from? What case management technology have I got? What's the MI? What's my productivity? How are you measuring? None of that's in place, because quite rightly, their business is either to be a bank, a retailer, a pharmacy. They're not a law firm. It's our core business. We know what we're doing. In terms of the US, you'll appreciate if I'm pretty guarded about my response on that, because this is something, the reason we put Andy out here 2 years ago, even if he was clearly on the wrong coast now, I actually realise that, is partly to understand what was happening here as an early stake in the ground so we could understand the way the market was going, partly to make sure, and Andy's brought me fully up to speed in terms of making me understand the power of tech and the way it's moving in the market over here. But we're also working very hard on the way in which we will enter the US market formally. And that's something that, if there's any wood round here, should happen within this financial year.
Yeah, so since we did get a little bit on now to the topic of technology, and I'd like to include Matt if he wants to chime in at all, but how does technology and innovation come into a law firm? What are the barriers, and how does the business model matter here? Just kind of want to...
In particular, I'd like to hear about the online delivery method. I know you all have a client portal. I couldn't register to see exactly what that platform looks like for the consumer side, but I'm curious about that part too.
I think the thing about technology is it's not, in our business, it's not a separate activity. It's not a separate functional thought. It's part of what we do, and everyone understands that. And we've still got loads to learn about what can be done in the technology, particularly after the conversation we had earlier. We've got loads to learn about what we're doing, and part of the reason I'm out here is because we think in Riverview Law, with the technology infrastructure and the culture and the model we've got a model which will do very well against traditional law firms and other competitors over the next 5-10 years. What I'm interested in is what happens next. How can technology change the way we run our business? What's the business that's going to kill Riverview Law? That's what we're interested in, and that's one of the reasons why we're out here now. I think culturally in our business, and again, this is the advantage of starting with a blank piece of paper, people come into our business, this is the way we do it. We don't do it any other way. So people automatically, when they're being recruited, they understand technology and the way in which they have to use it and the way in which they operate with it. For customers, it's quite interesting with customers. It's a really good question on customers. customers can access all of their, as we can with any client portal, we're not unique in this, they can access all of their data real time in terms of individual cases, all the MIM data and trend analysis, all of billing, quite easy for us because it's fixed fee, so that's not particularly difficult. All our reports that we put in, their management reports, etc. But I think the thing on technology is that the thing that strikes me over here is that while some law firms have adopted technology reasonably well, actually a lot of the technology adoption seems to have been in-house from the people we've met. Maybe we've just been fortunate in the general counsels and the firms we've met, whereas in the UK, it's just not been adopted much at all, quite frankly, unless it's come from a US parent company and it's been driven from there. So I think culturally, we've not had the problem because actually we're doing it from scratch. Andy?
I was thinking as well, I think there's a link here to the Clayton Christensen conversation we had on the innovator's dilemma, which is that I think for a traditional incumbent firm, to the question that you were asking, how does technology enter the law firm? I think increasingly I'm convinced that the answer lies in what Christensen talked about in terms of setting up a skunk work, so an autonomous business unit that is freed up to actually operate under its own auspices, not under the auspices of the mothership, as it were. And we're seeing some examples, so there are a few examples of that in the UK now. I suspect, could be wrong, but I suspect we're going to see more of that in the US as well. I think it's quite an interesting landscape to survey, and that's it's certainly in the UK. There are scenarios I won't name specifically, but there's one in particular, reasonably high-profile firm over there, where the skunk works, the lifeboat, as it were, that was deployed to experiment with new models, has the capacity to outgrow the mothership, and you can see that happening in the not too distant future. So I think that's one way that incumbent firms can adopt technology without having to leap through the many barriers, some of which we've touched on in this conversation, to a partnership model, to getting the buy-in from a large number of people who will say, yeah, sure, just wipe a couple of zeros off my paycheck for the next 2 years, because I'm forward-thinking and I'm happy to invest now out of my pocket for the future, because that's just not happening. But I think the skunkworks scenario is one in which it can.
Interesting. One of my colleagues spoke, I don't know, 3 or 4 months ago at a legal technology conference, and the attendees, so I'd be fascinated with some conference attendees, were all the CIOs from the major law firms. And after the first 2 sessions, all the panel turned to each other and said it was like a self-help group. Because everybody in the audience, the CIOs, they all knew what they needed to do. They all knew where the market was going. They couldn't get the decisions through the partnerships. And that was the challenge. It wasn't it's not that there aren't great people and they understand what needs doing. They know what needs to be done. It's just how do you get it done? And of course, that's very specific to organisations. It's different by organisation.
Yeah. Sorry. On this point in particular, I really want to challenge that, because my experience of talking to the CIOs is not that they all were on the same page about what they needed to do. It was absolutely the contrary.
Well, it may be just that in the UK, the CIOs are very advanced.
Do you want to introduce yourself?
Sure. I'm Matt Kessner. I'm the CIO of Fenwick. And thank you very much for organizing this today.
Sorry for interrupting the person behind you.
Yeah, I apologize to you. I owe you. Okay, couple things. Law firms, for whatever reason, Ralph, don't invest enough in technology and should. And that may change just because the cost of technology has come down. But for example, the really far ahead vertical market that you all know of is insurance. Like one of the leading products of man's invention, right? I'm kidding. It's as good as a joke gets from a CIO. Okay, they spend 12 to 16% of revenue on IT every year. Guess how much law firms spend on average in the U.S.? AmLaw 100 law firms.
3 to 5%.
Another? It's about 5 to 7% at best, and they lie. So he's actually right. It looks like it's closer to 3. CIOs do kind of know where this ought to go, and it ought to be robo-lawyer. I mean, frankly, that's where this is going with cloud, and that's the thing that I've been curious about you not saying, is that in most businesses today, they're seeing the crushing weight of cloud take down the magnitude of cost and technology by not 1 decimal place, but 4. And that can replace people. And I'm just curious as to why you guys aren't doing it either, because what I'm hearing from you at Riverview is that you're replacing lawyers with cheaper people, more of them who are more disciplined, and that's great, and that's process around people. But why in the world is this not quickly coming to an outsourced vendor who's crushing everybody already with a huge investment in IT.
We're almost out of time, just to let everybody know. So can we go till 2? Or, okay. So we only have a few more minutes. So.
Would you want to ask the two questions, and should we wrap them all together?
What?
Do you want to ask the two questions as well, and we'll wrap those together?
I don't know if we have time necessarily.
Let's ask the question.
Can I get just a very quick answer? Okay.
There's a critical idea here that goes to the question of technology spend and why aren't we doing more fundamentally, truly innovative things. And that is that all these pieces connect to each other. You can't just change a little. If you simply got better technology and didn't change the way you behave and the way the work is done, then you just have more cost and bright shiny object. So one of the reasons change doesn't happen faster is that you've got to change all the pieces or many of them at one time in order to make this work. So you have to staff differently. So to your point, you could make some changes that would require fewer human beings. Well, then you're going to have to think how you handle that. How do you do that? And how do you re-examine the demographics of the whole organization to fit to that new way of doing things? And it's that kind of fundamental business question that I think gets in the way, to the extent there are legitimate business questions getting in the way of faster change in big law. It's that kind of question, rethinking the whole thing.
I'm going to get one very quick answer to that then. One of the reasons why we're here, and one of the reasons I was pretty careful in my answer about what are we doing, is for exactly what you've just described. We're focused on what's the business that destroys Riverview law.
And that's not to say that we shouldn't make these changes, but that's why we're not.
Sorry about that. We're almost out of time. So if we can get a quick question and answer.
Quick question. The legal profession in the UK has this barrister-solicitor divide. And traditionally, the barrister side has been the more prestigious side. And the sense that I'm getting is that new outfits like Riverview Law aren't really competing with barristers. So going back to the politics of the enactment of the Legal Services Act, did that have something to do with the fact that the barristers were not worried that you guys are going to be competing with them?
Interestingly, Riverview Chambers, alongside Riverview Law, Riverview Chambers has 70 barristers in it and 19 Queen's QCs, silks. The barrister-solicitors distinction is a very interesting one. I choose my word very carefully. As a customer, I do not care whether my legal problem is solved by a top QC, a junior barrister, a senior solicitor, a junior solicitor, a client assistant, technology. I want my problem solved, preferably with some fixed pricing, client service, management information. So I think what's happening is you're seeing in the UK a massive change occurring. If the bar ever gets its act together, it's a big winner out of the changes in the legal services market, because what are they all used to? They're used to, ironically, low overheads, giving advice, by the way. Barristers give advice. They give opinions. They actually say what they think, rather than actually caveat it with all the other things that go around it, and I don't know what's actually been said. So you're seeing a massive change occur in the UK, and actually the Bar Standards Board will be regulating ABSs.
I want to, because we have a last question. Thank you.
First of all, I'd like to thank you for appearing here. I think it's very interesting. Last week, I attended a forum where I believe the 3 general counsels were from Hewlett-Packard, Twitter, and Facebook. And the takeaway, at least from my standpoint, from just being in the audience, was that a lot of the large American corporations are bringing their legal affairs in-house and expanding their corporate law associates. And they were even discussing, we want recent graduates out of law school so we can train them in our culture, our approach. Yep. And we're less interested in the fellows who don't, and women who don't make the partners in the large law firms. I'd like you to comment on that.
Yeah, I think in every large organisation will be different in the way in which it decides how to service its legal spend and its requirements. And there'll be a mixed economy between what they do in-house and what they then use third parties to deliver, whether that's law firms under traditional arrangements or whether it's legal process outsourcers, which we're not, or a legal advisory outsourcing business like ours. There'll be a mixed economy. I think what you can say with certainty is that the trend that you've just described is exactly what's happened in, if you take our other business, HR. People tried to do it themselves in-house first. Then actually they realised that actually it was easier to use third parties who understand it and dedicated it. So the question that the GC ends up asking themselves is, what is mission critical? In this business, forget other business, in this business, with all the pressures we've got, the chief executive, the finance director, the regulatory environment, what am I going to do in-house? Come what may, I'm going to do that in-house. Now, how do I source the rest? It's legitimate to say they'll build part of it in-house. It's legitimate to use third parties. There'll be a mixed economy. What I'm pretty certain of is that you'll see a switch from traditional providers to either a mix of people like ourselves and other new entrants and a combination of some changes in-house. Over time, I don't think in-house is sustainable unless they're prepared to make the investments in culture and change and technology. And the point about technology is it is getting cheaper, though, of course, which makes a big difference. But I think it's a mixed economy. It just depends from customer to customer.
We're out of time. Thank you, everybody. Thanks to speakers.